Hello, everyone, and welcome to another episode of Women Winning Wednesdays. I am your host, attorney Elsa W. Smith, and I'm the owner of the law offices of Elsa W. Smith, where our mission is to empower women through estate planning. We have a good show for you today. We're going to actually be reviewing, or it's the part one of this review of our estate planning checklist. It's a 21-point checklist that we created. It's on our website at elsawsmithlaw.com in the resources section. But I thought it a good idea to just go over points covered in the checklist, as well as answering some common questions that are raised. So as you saw on one of the taglines, please let StreamYard view any questions or comments that you have during the broadcast. And again, I'm so appreciative of you being able to join me. Feel free to share this video. We are streaming on YouTube, LinkedIn, and Facebook. So with that said, the topic, estate planning checklist, part one. So here we go. One of the first things, that you should consider, and this is one that most people are obviously thinking about, are wills. All right, so let's start talking about those. In very simple terms, a will is a legal document that dictates how you want your assets to be distributed after you die, right? You create it. Can it be amended? Absolutely. But it has no effect until you die, but you can change it and amend it, as I said, whenever you want. To be valid, the document, that will, has to comply with several requirements under your particular jurisdiction's laws. In Maryland, for example, a will doesn't need to be notarized, but it does need to be witnessed, and you need to have capacity, meaning that you understand what it is that you're signing, what the property involved in your will, and you need to be able to appreciate what it is that you're doing. That's what we talk about capacity. That's what we're talking about. A will also includes specific instructions on how you want your estate, everything you own, to be distributed. Now, let me pause here for a second, because a lot of people say, well, I don't have an estate. Let me correct you on that. If you have a bank account, if you have a car, if you have any kind of personal property, things that you own, clothes, shoes, collectible items, really, and even digital assets, those are all part of your estate. That's all your stuff. So it needs to be protected. So going back to the will, it includes instructions for how you want your estate to be distributed. And you can also include instructions on tangible personal property, like the ones I mentioned, jewelry, furniture, and so forth, as well as naming guardians for your minor children. So why do you need a will? So let me say this, any type of person, whether you're married, divorced, single, child-free parent, or a parent, whether you're in good health, bad health, particularly if you're in bad health, you should have a will, for the simple reason that without one, you can't determine who is going to receive or who should receive your property. Now, each state has a plan for how property must be distributed if you die without a will. That's called dying intestate. And those of you who follow this program know what that word means, because I have mentioned it many, many times. And we do not want anyone watching this show to die intestate. Now, if you have children, if you have causes that mean something to you and that you want to be a blessing to through your estate, then you definitely, at a minimum, want to have a will. Now,